Now, when I first looked at this case, I saw something different. First, I saw this is not so much a Second Amendment issue, but a violation of the Fifth Amendment's Due Process Clause. See, just like any other property, the government can only take away a right following due process of law, which the Free Legal Dictionary defines as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. In order to suspend the right of Mr. Rahimi to keep and bear arms, the government must show that it followed a process that protected his rights. The first right to look at is the right to be considered innocent until proven guilty. While not specifically called out in the Bill of Rights, it is recognized under the Ninth Amendment, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people." The most fundamental aspect of innocent until proven guilty is the prohibition of punishment until an actual finding of guilt. That's not to say the accused cannot be detained or otherwise restricted, but that it should be based on probable cause in the details of the case at hand. As was stated by the Solicitor General in the petition for the certiorari, in order for a court to prohibit the possession of a firearm under 922G8, it must fulfill three criteria. First, there had to have been a hearing at which the accused had an opportunity to participate. Well, Mr. Rahimi was notified about the hearing and did participate. That's not a finding of guilt, but seems to have provided evidence of probable cause. Second, the order must restrain someone from threatening an intimate partner. Now, this would seem to violate the concept of equal protection, since a restraining order against a stalker, a business associate, or a neighbor would not qualify. Again, while the Equal Protection Clause of the 14th Amendment is limited to the states, the equal protection in federal law is just as protected by the Ninth Amendment. The third criteria for an order to trigger 922G8 has two components, either of which is necessary. Either the order specifically prohibits the use or attempted use of physical force, or a finding that the accused represents a credible threat to the physical safety of the intimate partner or child. The former is dubious because the prohibition against a use of force can be included in a court order whether the accused has been shown to be violent or not. I'm not fully behind the latter because a judge's findings may be subjective and not based on probable cause for the accused's actions. Now, looking at 922G as a whole, though, I found a more serious problem with the law. It shall be unlawful for any person to ship or transport in interstate commerce or foreign commerce or possess in or affecting commerce any firearm or ammunition or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Now, Article 1, Section 8, Clause 3 of the Constitution authorized Congress to regulate interstate and foreign commerce, not to regulate anything that passes through said commerce. The Commerce Clause reads, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Since Congress only has the power to regulate interstate commerce, and this law does not regulate commerce of any kind, 18 U.S.C. 922 violates both Article 1, Section 8, Clause 3 and the 10th Amendment of the Constitution, and is therefore void. As the Supreme Court stated in the case Ex parte Siebold, an unconstitutional law is void and has no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment.